I do know that they, like Mr. Reeves, filed a motion to quash in advance of this hearing, which I understand we're not now entertaining. Okay. So with respect to state police, I think we argued extensively on April 14th the issues relating to the non-production of documents. I don't want to reinvent the wheel, but here's what I do want to say. In response, the state sent over to my office 2 jump drives and a letter on 4/13/2022 at 1:52 in the afternoon. The hearing was the next day. In that letter, there is one reference to items 4 and 5, which are looking for the text messages and emails. And text messages and emails, again, I inserted specific terms, among which were Carl Cavalier, Ronald Green, cover-up, excessive force, book, secondary employment, business, undercover name, pseudonym, pseudo-name, retaliation, assault, and battery. I identified to whom I wanted those emails, whether they had been sent or received. And the response that I got on April 13th at 1:52 in the afternoon was, as to item number 4, please find the enclosed responsive records. Of course, nothing was produced. It said overly burdensome and we could not review all requested documents. As to item number 5, overly burdensome and we could not review all requested documents. At no time was a motion to quash. At no time was there any communication to me that said, as they now apparently complain, there were a lot of documents and it's too much for us to produce, even though our IT guy apparently got them together by April 4th of 2022. And so now here we are. This is now the second time we're addressing the issue of whether they produced it. I'm not an unreasonable person. If you came to me and told me, outside of a pleading, which we just got in this case, that there's all these documents and all these emails and we want you to pare it down, I'm happy to do so. But for goodness sakes, you don't get to show up in court when the subpoena's been issued and say, we're just not going to produce it, it's overly burdensome. You have to object, you have to file a motion to quash. It's like the horse is out of the barn and we're running after it saying, come back, come back, come back. And then the horse gets to run into another barn and argue, hey, look, there's not enough hay here. It just doesn't work that way. I mean, I hate to be silly, but come on. I mean, as I've indicated, Mr. Cavalier is out of a job. We contend he's been fired because he was speaking up about a killing. He wrote a book. He was fired for writing the book. What we asked for was very specifically targeted with those terms. If they had a problem, then somebody, for goodness sakes, tell me. But don't just show up and say, gee, we're sorry.
But Ms. Craft, we agree that relative to this appeal, for which this subpoena was issued, all we're dealing with is a 200-hour suspension, correct?
The 200-hour suspension, yes, sir. But the 200-hour suspension, so you know, was a placeholder until they got the termination stuff together and fired him. Then they never returned to work, and that was never the plan. But with respect to the issues that we did subpoena the documents, it is not sufficient under the Code of Civil Procedure or this Commission's rules to put a little bullet item that says it's overly burdensome and we haven't had time to review it. And that's where I am. As frustrated as it seems and as frustrating as it is to Mr. Cavalier, it is a subpoena that was validly issued by this board. There is a procedure, file a motion to quash, but you don't get to come in after the fact and complain about it, especially since according to their own affidavit, they had all those documents by, I believe, April 4th, 2022. How come nobody called me 10 days ahead and said, gee, Jill, it's a big old stack. Do you want the whole thing or do you want to pare it down to something else? That never happened. Furthermore, I'll note in their motion to quash, for the first time, they raised some notion of privileged communications between Colonel Reeves and the governor. I'm sorry. They are public officials. They don't get that kind of privilege. Mr. Reeves is not a lawyer, and the governor is not acting in his capacity as a lawyer. Similarly, they raised some sort of issue about privilege among command staff. Since when? These are public documents. Again, I would ask that they would be held in contempt, and at least we get the documents. If there wants to be some limitation at some other now new hearing on a motion to quash, fine. But I'm submitting to you that doesn't excuse their not complying with the rules and not complying with the subpoenas. Thank you.
Any response?
Yes, Chairman and Commission members. DPS diligently tried to fulfill the subpoena request.
What effort was that?
On the day we received the subpoena, an email was sent over to our TBS, which is the Technical Business Support, and they sent over the search that Ms. Kraft sent to us to OTS. I have Mr. Jolie here from OTS in the place of Derek Williams, who submitted the affidavit to state that they received the request, they ran the search, and they returned it to us. I also filed with my motion the search that was done. Myself, I'm not an IT person. I received this, I didn't know what the estimated totals meant or anything. We received it on a jump drive. We had other public records requests, other committee hearings and things. It wasn't on the 4th that we looked at it. It was after the 4th. And
When was it looked at?
I want to say, looked at it on the 11th, and our plan was to go through it. When I went through the first few emails or whatever, I was like, this is going to take more time because we have to delineate the emails that would be privileged emails and confidential emails that would have to be redacted and go through it. It wasn't, I didn't know the
But
exact.
normally, you know that's part of the process of the
Yes.
document production.
Yes.
But you waited until the 11th to look at it for the first time?
Because we had other hearings, we had a lot of things on our calendar, and we
You
also.
never filed a motion to quash?
I
saying-
never filed the motion to
Asking
quash.
this commission to quash it, or to postpone the hearing, or to do
I
anything?
did not do that, and I did not, and I have, I'm not gonna even, I didn't do that, I admit that. But we were diligently trying to get all of the information that Ms. Kraft asked for. I was in communication with Mr. Brad, is it Brad? Conrad. We spoke a couple of times, and I told him, I said, we're trying to get all of the information that is needed. When I
Is
realized
that before or after the 11th?
that was, no, that was, I want to say, no, that was around the 11th, because I received the email from him. And I also asked him, I said, well, are you gonna give me copies of the recordings that you mentioned in your exhibit list? And they received that. So what we did, I was speaking to him on the day of before the hearing, and he said, don't worry about it, just give me what you have. And so I had the ladies from our office to take it to him. Yes, Ms. Kraft is right, we have the information, but it wasn't until after the hearing, I knew it was a lot, I didn't know how much it was. We contacted OTS, they met us at our office, we sat down with the IT person. I said, I know it's a lot of information here. Can you tell us exactly how much information is here? Because also we had to fulfill a public records request, I believe, from the advocate on just how much. So their specialist came in, ran through the emails that they had sent to us and said it's like 3.4 million, pages of document. I said, well, they're the numbers people. He said, that's about 7,000 reams of paper. I said, I don't know what that looks like. Can you tell me what that looks like? He said, that's about 65% of the Empire State Building. At which time I said, that's impossible. There's nowhere in the world we would even be able to print all of the emails. The emails are not even printed. We were looking at them through a drive. And so we realized
But all that's information you got after the hearing.
After
You
the
didn't bother
hearing.
to get any of that information before the date of the hearing.
No, because my goal was to provide it. My goal was to provide it. I was diligently trying to provide it. And I did not file a motion to quash, but after the hearing, I was gonna try to provide it, and then I was like, this is impossible. As far as the text messages are concerned, we had someone from our department and someone from OTS also contacted the wireless department. They said that a subpoena would have to be sent, but it would only give you information. Yeah, it is 48 hours of messages. AT&T and 7 days on Verizon. And I agree with Ms. Kraft. If we could narrow it where it's manageable, then we could try it, but it's no way we'll be able to honor the items 4 and 5 on the subpoena. We didn't ignore the subpoena. We provided 1, 2, and 3. We were just unable to provide her with 4 or 5. We were not trying to be disrespectful. We were not trying to ignore the subpoena. I was diligently working, trying to fulfill the subpoena requests. And I did not file the motion to quash. I thought, from my conversation, I thought, okay, I've given you 1, 2, and 3. 4 and 5 overly broad. We don't have time to go through it. When he says, don't worry about it, just give me what you have, I was under the impression we were good. I came in here, I was completely blindsided. I'm not trying to hide anything. I didn't expect the motion to compel. My practice has basically been in district court where if it's some type of discovery, you have a conference, you know, and none of those things happen. So I would do whatever the commission require, but we are unable to fulfill item 4 and 5. It is completely impossible for us
Okay,
to
but right, that's relative to your motion to quash. Right now, I want to focus on the motion for contempt
Yeah.
and why it is steps were not taken. So you say you spoke to counsel. We'll hear from him as to his version of that. But what is your version of what that conversation was?
Mine?
Yeah, do
Okay.
y'all agree on what the conversation said?
He and I spoke. I was completely shocked when I got here and he said the things he said, because I hadn't spoken with Ms. Kraft. I've been communicating with him the whole time. And mind you, I asked him for some things and.
Well, right now, we want to focus
Yes.
on what you were subpoenaed to produce.
Yes, I did not produce 4 and 5. I thought I communicated to Ms. Kraft's office that we were unable to review those documents and we couldn't release them. It was overly broad. And the reason I said it was overly broad is because I knew it was a lot. When I came here, I told you it was a lot. I knew we couldn't do it. But I didn't know that that lot was 3 million pages. I didn't know that at the time.
If you don't mind, what's your, what is?
Can I also, I'd like to introduce the emails that we do have from Ms. Hollins. and specifically the one from April 11th, and this is what she told us on April 11th. We are still in the process of collecting documents. Hopefully we can make this available to you by close of business tomorrow. Also, we are awaiting recorded conversation from you that were mentioned in your list of exhibits. Please advise as to when we will receive those recordings. As I understand what she just said, they had all the emails we requested on a jump drive in their possession on April 4th. I'd like to offer, file, and introduce the email where she specifically says,
You'll have
Any
it.
objections?
No, that's the truth, on the 11th. That's the truth.
So is that,
She said on 4, on the 4.
Oh, no, I received it on the 4th, but I emailed him on the 11th. The 11th was when I was able to look at that's exactly right. I was able to look at the, jump drive, and I saw that it was a lot of information. But
was that email following the conversation you had?
that was before.
That was before?
That was before, and
So, but in the email before the conversation, you were still indicating that you were going to
yes.
attempt to produce the rest of it
Yes.
tomorrow, but that.
It didn't happen, and that's when I called him back and said that we're not gonna be able to go through all of this. It's too much. That's exactly right, on the 11th, because on the 4th, when we received it, mind you, we were still producing information to the House, to the Senate, we had other hearings, we had a whole lot of things going on. So,
I would like to focus on the conversation
okay,
that
absolutely,
you had.
yes,
And I understand that email that we just introduced came before the conversation you had.
yes,
And then you had a subsequent conversation where he said, give me what you have.
yes.
Did he at that point excuse you from giving him the rest that you?
That's what I thought. I thought he realized what our search was so big, they can't handle it. I assume they realized that their search was so massive and it was so many documents and we weren't gonna have enough time to go through all of the documents, to segregate those documents out there that.
As best you can, tell this commission the words that were exchanged between you and he.
I called him to tell him that we are trying to get all of your information. It's right here.
Do you have a note of the conversation?
I don't have a note.
Oh, okay.
I'm just going on my memory
Okay, go ahead.
of what I said, and that I wasn't gonna be able to fulfill the request, and that, and he even acknowledged, yeah, I know it's a lot.
Okay,
He even acknowledged that.
okay.
And he said, don't worry about it, send what you have. So I told the girls in the office to get all of the information together. As a matter of fact, they were sort of taking their time. I say, take it, take it, take it. Take what we have. They was like, well, Ms. Gay, I said, just take it. And I said, but we can't. We couldn't give over the jump drive from OTS with the documents because we didn't have enough time to go through.
And
So,
Mr. Chairman.
Go ahead and identify yourself. please.
Yes, this is Brett Conrad, representative of Mr. Cavalier as well. I acknowledge that we received the email from Mrs. Holland that day as reflected, I believe it was on April 12th, and we did have a subsequent conversation. But the purpose of that conversation was not for her to explain, hey, I can't get you these documents. We were discussing resolving the matter. In connection with that conversation, she said, I still need to give you what's in the subpoena. It's a lot of information. I said, well, give me what you have. At no time did I represent to her that LSP was alleviated from their document production in connection with items 4 and 5, or that she had relayed to me that, hey, we had done this search and it's coming up with millions of pages and any of that. None of that information was conveyed. My understanding was that those documents were going to be produced, and during our conversation, she did not explain to me how those documents were going to be produced. The next thing we know, late in the afternoon, we're getting a jump drive that day. And so the representation that I communicated to Mrs. Holland that LSP was alleviated from 4 and 5 is just not accurate. And I'm welcome to answer any further
At
questions.
best, you would say there's a misunderstanding of what you.
I wouldn't even say that, Commissioner. It's not a misunderstanding. I did not represent to them that they were alleviated from that. I represented to them, send me what you got, because we were less than 24 hours from the hearing. But at no point in time did I tell them that they were not obligated to comply with the subpoena, or that I was releasing them from that, which I don't even have the power to do.
That's the conversation, that's true. And maybe I misunderstood you, but that's exactly what he said. Just sitting there what you had.
All right, thank you. I appreciate your concession on that point. Yes, sir.
So there was a jump drive that was furnished, and did that have any response to number 4 or 5?
No, it was furnished on April 13th at 1:59 in the afternoon, and it contained documents responsive to subpoena requests 1, 2, and 3.
Okay.
Yeah, 4 and 5 is the letter where it said,
Yeah.
we're still reviewing or whatever it is. Yes, sir.
Thank you.
Anything else?
No.
Any brief response?
No, sir.
So that's the submission of all of the motions for contempt, if I understand correctly.
Yes, sir.
All right. So would entertain a motion to go into executive session to discuss the allegations of misconduct.
You don't want to do their motions to quash or anything from
I think we pretty much said we're gonna do the motions
Okay.
to quash
All
in
of
the
them,
next,
okay.
the next hearing. If we entertain them.
Okay.
Okay, so would entertain a motion to go into executive session to discuss the allegations of misconduct on the part of the witnesses and the department relative to the subpoenas and the request for contempt. So we have a motion,
Second.
take a roll call vote, please.
Brian Crawford,
Yes.
Aaron Knapp,
Yes.
Carol Creed, Louis Semenya.
Yes. Okay, same instructions as last time. Take you and all potential recording devices to the agent.